Welcome to Second Half Conversations. I'm your host, Sondra Ziegler. This is a space to discuss all kinds of topics about the second half of life, from complicated legal topics like wealth protection and business succession planning that we break down in a practical way, to long-term care planning and care navigation when you have a loved one on a care journey, to leaning into fully experiencing new seasons of life, of work, and relationships. Our team and guests are here to equip you to take full advantage of where you're at. Because if done right, the second half is the better half. Let's get to it. Welcome again to Second Half Conversations, where our goal is practical guidance that helps families have peace of mind in the second half of life. Today, I am thrilled to be joined by Sharon Wright, who's of counsel with our firm and does an amazing job in estate planning and probate. We're going to tackle 3 estate planning misconceptions that can quietly create big problems. But before we get to that, I wanted to let you know a little bit about Sharon and then put her on the spot to tell us a little bit about her why, how she got into estate planning, what her background is, her educational background, and just help us understand why she does what she does. I just love hearing that story. So Sharon is board certified in estate planning and probate law. She received her law degree from Baylor University School of Law. And for those of you who are listening to this from West Texas, give her a break on that because she's super smart. And so we want those Baylor Bears when they're as smart as she is. Sharon's specialization in estate planning and probate law is also complemented by a deep understanding of financial planning and asset management. We hired Sharon in 2024. I'm right about that, right? The end of 24. She joined our firm, and she's been an invaluable addition and brings so much insight and care to the work that she does for our clients. So she's been practicing for 16 years now. And so, Sharon, tell us how you decided that you wanted to do estate planning. There's all kinds of law that you could have gone into, but I guess maybe let's back up for a second and say, how did you decide you wanted to be an attorney?
Well, first of all, thank you. Thank you, Sondra, for a sweet introduction. My going to law school had been planned for many years by my grandpa. He always said he wanted me to be an attorney, and that stuck in my head. And so my brother and I both ended up in law school together. He went the criminal route, and I went the estate planning route. My undergraduate degree was in finance, so I would say I'm more of a math person, all along. So that's what has steered me into the estate planning realm. Even in law school, I focus, like you said, in estate planning because I like math. I like dealing with money and trying to save people money. But then also, part of the bigger picture of helping families, create legacy. Again, I'm very close with my family and my grandpa. And so that was always in the back of my head. I enjoy, helping others leave a legacy.
Okay, I love that story. I had not heard that story about your grandfather. Yes. So was there ever any point, I don't know, when you were younger that you thought, I don't want to be an attorney. Why does he think I should be an attorney?
I graduated early from undergrad. So I was already finished when all my friends were still there. And so at Baylor, I could continue, go to law school. So it was a practical, logistically it worked too. And I wasn't quite sure, where I was going to end up. So it fit in my path.
That's fantastic. I love that. So I know your previous firm, you were part of I would call it, because I'm not an attorney, I would call it a general practice, but you might describe it differently, more business law related, more oil and gas. Is that right?
It's mainly oil and gas, but I was taught by the greatest attorneys around that, yes, they knew a great knowledge across many fields. So I feel like I was very, very honored to be able to learn a little bit about a lot of different areas.
Well, that was appealing to us when we were looking at your resume and wanting to add an attorney was to have someone with a breadth of knowledge across different areas. Because in estate planning, you can have a lot of different factors come in, and it's just really it's good when you have that broader context and the context of financial planning and asset management too. All of that is so helpful when we're helping people plan,
Right, definitely.
to protect their assets and make sure everything ends up in the right hands.
Definitely. And I'm part of a small community, so where I would be the attorney, and several questions would come up, and you have to be able to at least steer them the right direction.
Yes.
No matter the issue.
So, okay, I guess let's dive in, because when you sent me what you wanted to talk about on our podcast, I was excited that you wanted to talk about 3 misconceptions that can cause big problems. So, tell me what your first misconception is, or I can say it and you can tell me about it. This one was intriguing to me because I had not really understood that this was a misconception out there, but apparently it's pretty common. Misconception number 1 is Texas gets my property if I die without a will. So when someone says that, what are they really worried about, and what actually happens in Texas if you die without a will?
Yes. Well, yeah, I cannot tell you the number of times somebody has come into my office, and that's where we start. They say, I just don't want the state or the government. I hear that one a lot too, to get my property. And so while Texas does decide, who your heirs are, who would take your property if you pass away without a will, Texas actually, being the heir of your property is not likely to happen. That's only if they can find no one else, basically, and that you're related to. But it happens much more often than you would think.
Okay, so in plain English, what is intestacy, and who typically inherits under intestacy rules?
So intestacy means passing away without leaving a valid will. So uh, and when that happens, we look to who the heirs of that person would be, which is defined, who the heirs are is defined by Texas law. And without getting too much in the nitty gritty, it depends on your family background. So if the person was married at the time they passed away, whether they have children, whether those children are also children of their surviving spouse. And then it also depends on the type of property, which kind of makes it even a little crazier and nitpicky. It depends on community property versus separate property. And it also depends on whether the property they're passing is real estate, meaning a land or home, or personal property, meaning a bank account. So all these things factor into who takes your property if you pass away without leaving a valid will.
So, what are some of the most common surprises that families experience when there's no will?
It's when somebody passes away with a spouse and they don't realize exactly who owns the property, whether it's the person on the title or whether, how the bank account is styled. And they're surprised. They're surprised because they didn't, take the time to plan. And more often than not, the big surprises happen in a blended family situation where, there's his and her kids or children of a previous marriage. And a lot of times, people have been married for many, many years. They consider those kids their kids, but they never were truly adopted. They never, corrected the title or looked at the accounts. And that's when it's, kind of a difficult conversation to have to explain who actually takes in that situation.
Can you tell us, is the Texas takes it idea ever true? Like, if there are no heirs, how rare is that scenario?
It is true only if they truly cannot find an heir, and it's never happened. I've never heard of it really happening. If that helps at all. And I know it's not even. They take significant steps and many years to try to make sure there's nobody out there before it would go to that.
Okay, well,
so very rare. Very, yes, very rare. But
That should set some minds at ease out there. So, in listening to what you were saying about people not always being clear about how they own what they have and how that can cause problems sometimes. How do beneficiary designations and joint ownership change the picture? And what I'm thinking about is I think it would be helpful for our listeners to understand a little bit about what passes through the probate process and what passes outside of it
definitely.
in terms of
So,
assets.
some assets, kind of going back, those personal property assets, bank accounts, brokerage accounts, they are technically governed by the contract, from the bank. So if somebody sets up with the bank a payable on death beneficiary designation, sometimes it's called a survivorship agreement, where they name who takes their property upon their passing, that contract will control. So that property is going to pass immediately, however the contract is stated, however the beneficiary is designated. All other property, whether it's real estate, bank accounts that don't have that kind of designation, all of that falls into what's considered part of the probate estate. Just talking, bare minimum of a person who doesn't have a will, doesn't have trust planning, anything like that. And technically that would be the probate estate.
I've heard on bank accounts, sometimes there's a misunderstanding about who's a co-owner versus who's an authorized signer, because those are two
Right.
different things. Just because you can sign
Definitely.
checks at the bank does not mean you're the owner, right?
Exactly. And that can be added to our list of misconceptions, because so many times people will come in and almost dismissively say, I'm on the account, no problem. Because during their parents' lifetime, they're a signer. Like you said, they can sign the checks, they can act, but you just have to be sure and get that actual account agreement to be sure there is a beneficiary designated for it to pass upon death. Sometimes
Okay.
bank call this a signature card or account agreement, but it's definitely important to look at the actual agreement and make sure the person is a joint owner, or it would be payable on death to that person, not just a signing authority.
What would you say, just in all the years that you've done this type of work, what is the emotional or / administrative burden on the family when there's no plan? When there's been no planning, what does that look like 1 week after death?
Your family's already in the grieving process, and if they step into a mess, which happens more often than not, it's awful for the family. That I tell people, you're not only planning for who gets your stuff, who gets your money, anything like that. You're doing a one last I love you by not leaving a mess, by giving them an organized, plan, so that your family doesn't have to step into a nightmare. I can't tell you how often a family comes in almost mad at their loved one because of the mess that they left, that they're having to get stuck picking up the pieces.
That was my next question. I thought, without naming names, can you think of a situation that happened, or can you describe a typical case where a family thought they were fine without a will and that went sideways?
Definitely. One that I always think back to was a surviving spouse. She had been married to, her late husband for many, many years. They owned this, beautiful home that they had updated together and that she had lived in, over 20 years. Her husband passed away without a will, and he left his daughter. So it was her stepdaughter. Well, the surviving spouse, she was ready to downsize. So she was, the house was too much for her. And I had to be the bearer of bad news, because the home was actually his separate property before marriage. They never got around to updating the deed, even though, 20 plus years at living at the home, fixing the home up, that the stepdaughter, owned an interest in the home. The surviving spouse, she had a right to live there since it was her homestead. But with regards to trying to sell the home and use those proceeds to, to downsize, she was not going to be able to do that without the stepdaughter agreeing. And they didn't have the best relationship. And, I remember that case specifically because I remember her being upset with me when I was the bearer of bad news. And it just wasn't a fun place to be because it was an easy fix he could have handled. Even if he wanted to make sure his daughter wasn't cut out, there were ways we could have done that in a better manner to protect his spouse and his daughter.
Wow. Well, I've heard it said over and over that blended family planning is even more crucial than if it's not a blended family, but that's a good example of why. Okay, misconception number 2. You just spoke to this a little bit. Our house may really be his house, separate property, and the inception of title. This one shocks people when someone says our house. Why might it legally be someone's separate property? You just talked about it, but maybe there's other examples of that too.
Right. So the rule in Texas, since we are a community property state, you look back at when the home was purchased and who exactly, purchased the home. When somebody buys a home before marriage, even when the spouse moves in years later when they get married, it's still considered, that person's separate property if it was acquired, before marriage. So anything before marriage or even after marriage, but they acquired it through gift or inheritance is considered separate property. So, even if taxes may come in both their names, sometimes the appraisal district, adds in the spouse. Even if the spouse spent her money fixing up the home, technically is still separate property of the husband if he purchased it before marriage. Or wife if the wife owned it before marriage.
Okay. Can you explain to us inception of title in sort of common language?
Yes. And inception of title, basically what I just said about when the point in time of when title was acquired. So when they bought the home, or whether they or received the home, if it was, through inheritance or something like that. That's the point of time. You look at the title and see, was that person married? Even if it's, in one person's name, if he was married, it's still considered community property. But if when he acquired the property, if it was before marriage, that would be considered separate property.
Okay.
So even that, I guess, if somebody acquired property after marriage, but only one spouse is on it, sometimes that certain spouse says, well, I'm the only one named on the title. And not necessarily. In Texas, it's a community property state. It's a presumption that the wife still has an interest, even if it is in one spouse's name, without any kind of separate property designation or other proof to explain.
Okay. So if a couple discovers, okay, wow, this really isn't truly ours, what planning tools can align? You mentioned a deed. Is that what needs to happen? They need to come in, do their estate planning, and also retitle assets like real property into both of their names?
Yes, definitely need to look at the full picture. But yes, that would be part of the process. Would be to make sure that everybody's on the same page as to who owns what now and going forward, and then who they want to their property. Who would they want to inherit the property upon their passing, and make sure those all align with how the title is currently held. A lot of times people just don't know. They assume they hold it in one way, but and assume it'll pass a certain way, and just for there not to be any surprises. That's why planning is key. So you can all be on the same page.
And you mentioned it needs to be part of of a holistic plan, or at least that's what I heard. And I'm guessing in that conversation, when you're talking with maybe that couple where one of the spouses actually, owned the house before their marriage, if it's a blended family, that discussion is a more in-depth discussion when you're talking about either retitling the house in both their names, or if there were kids from that prior marriage, talking through with both spouses what they would want to have happen with not only that asset, which is many people's largest asset, is their home,
Right.
but all of their other assets. How in most cases, if the couple is sitting in our conference room, each of those spouses in this blended marriage would want the other one to be taken care of. If something happened to them, if they predeceased, they would want assets to go toward the maintenance and the welfare of that remaining surviving spouse. However, there's also the issue of taking care of the kids and making sure the children from the previous marriage or marriages, if they both had kids, are not disinherited by the planning. So that is a much more in-depth conversation that you're having at that point.
It is. And there's just so many options to be able to address those concerns. And yes, protect the surviving spouse, but also look out for the kiddos and make sure that they don't have to, wait for their inheritance either. There's definitely so much that you can do. If you can be proactive about it rather than, after the fact and hoping the family can come to an agreement.
I think that brings us to misconception number 3. I don't have enough. Oh, go ahead.
I was going to add in one quick example that I thought of.
Yes.
That happened actually this week was a home that the couple purchased during their marriage. So it is a community property home, but wife has since passed away. And she has kiddos. They have kiddos together. And then she had kids from a previous marriage. Again, they had been together for many years. He considered those kiddos, I think they lived with him since they were 2 years old. Wow. But the home is not technically a 100% surviving spouse at this point in time because she passed away without a will. We are now having to go to the kiddos to try to get them to convey any interest that they may have from mom, who passed away without a will, in the home back to her surviving spouse, back to dad or stepdad. And so we're just kind of at the whim of the kiddos. He definitely would own his half, but we're just trying to, make sure that he has all the interest. And that's an example of they bought the home together, but it's still a mess.
Wow. Okay. Yeah. So that does lead us to misconception number 3. I don't have enough money to worry about estate planning, or a situation like what you just said, when I think some people, even if they know they have assets and they would want to make sure those end up in the right hands, they may just assume that, well, if we're not fighting and we're happily married and our kids all get along, what's the big deal? So when people say either I don't have enough money or I haven't gotten around to it or I'm not worried about it, what are they overlooking that estate planning actually is going to protect them from?
One main issue you just said is not leaving, obviously your family with a mess. It's an act of love to leave your family prepared, no matter the size of the estate. But it also, prevents your hard-earned money from going to have to fix these issues. So a lot of times early planning prevents big expenses later, big probate costs, big costs to try to fix the deed or try to, get some sort of family settlement agreement in place. So often the people who have not planned, that is the most expensive following death, just to try to, clear things up for their family. Even in situations where the families get along, there's still a lot of work that needs to be done to clear things up, to allow the family to, sell the property or whatever needs to happen. But it can get expensive really quickly if you don't, plan ahead.
I think, there's a lot of lack of understanding about how expensive that process can be after the fact if the planning's not there. And I also think about some of the non-financial reasons to plan also. So when people come in to our office and we're doing a will or a trust for them. We're also going to be doing some foundational documents like powers of attorney. And so I was wondering if you could think about, or if you could speak to that about what those documents
Yes.
do for people and why they're so important, both medical and financial and all of that.
Yes, I'm very glad you brought that up. Part of estate planning, it's not necessarily, like you said, just for planning after you pass away. It's also planning for during your lifetime if you are unable to make medical or financial decisions or act on your own behalf. Estate planning allows you to designate, who you'd want to be able to make those decisions for you. And just so much more goes into it on the front end, to be able to make sure your family has enough powers to do what needs to happen and to save money in the long run, is to plan ahead of time.
I think about also avoiding guardianship is one of the things that as people get older and are not able to make their own decisions anymore, and we hear about it all the time. But if they are able to come in and do their estate planning and name who they would want to serve and make their decisions for them, if they no longer have the mental capacity, or if they have a sudden health event like a stroke, or they're in a car accident and have a coma. I mean, they're in a coma.
Right.
Being able to
Or
name,
even on vacation, and you need your kiddo to step in to do something for you.
Oh, absolutely. Yes. That's a great example because I never think about those practical things like that.
Mm-hmm. Yes. But yeah, Sondra, it just goes back to kind of our first misconception. If you don't plan ahead and name, there are laws that will allow certain family members to make those decisions. But do you want the state to tell you who those people are, or do you want to, name them yourself and decide what exact powers that person will have?
Oh, that's an important one too. I know we could go down a whole rabbit trail about long-term care planning and Medicaid planning, but we'll save that one for another podcast, which I would love to have you back on for, because the one of the things people don't understand too is many times that if they have a power of attorney in place, it may be the case that it's not robust enough if they're needing to plan to qualify for benefits, for public benefits to help pay for long-term care.
Right.
So important to get their estate planning ducks in a row, as we like to say, not only a will or trust to determine, what happens to their stuff when they die, but also what happens before you die. What if you don't die? What if you have a really long illness and need the care of another person, either at home or you need care in a facility before you pass? And this is an unforeseen journey. It's an unforeseen stress on the family, and certainly an unforeseen expense that could potentially wipe out the savings of a couple pretty quickly if you had to be in, say, a nursing home for years. So anyway, very important to get the estate planning done, but for not only what's happening now, but what could happen in the future, being able to do that planning that way.
Well, and I know we're running out of time, but we didn't even get into the fact that, a couple with kiddos under the age of 18, that's a whole nother thing to consider and think about who's going to possibly raise your children, and who would be in charge of the money, overseeing the money. And those can be two different people. But again, it's proactively planning is key.
So tell me about that a little bit. Because I think that's something that most people wouldn't know. I mean, I would know it if I weren't involved in the firm. But so you can have a different person named to be in charge of the money that you leave after you pass. Like if you and your spouse were to die in a common accident, for instance, and you left minor children behind, you could have a separate person in charge of the money and a different person in actually raising the children. Talk to us a little bit about why you would do that in some instances.
Exactly. Well, a lot of times, obviously, if you're naming somebody to watch over your kiddos, you completely trust them. Wouldn't care if they also made the financial decisions, but that's obviously a huge burden to put on somebody just to raise the kiddos. So naming somebody separate kind of just adds another layer of protection, but also gives them a little bit of a break to not have to, take on so much of the burden. So a lot of times I see people doing it that way, or who, the sibling that you would want to, has other kiddos, has the cousins they raise, may not necessarily be the best person to, invest the assets like they should, put money away for the kiddos, like someone else that you would trust more, or be able to, handle the finances in a better
You
way.
might have a sibling who's I mean, this is an extreme example, but you might have a sibling who's a financial advisor and they would just be perfectly suited to help manage money.
Exactly.
Whereas, like in your example, maybe you have another sibling who has kids of the same age. So I could definitely see in that situation where it might be good to name two different people. So that kind of leads me to my next question. Or a similar question. What life events, in your opinion, should trigger planning? Because I think some of us think about estate planning as a one-time deal. I'm gonna do my estate planning and now it's done forever. But we know that there are things that can happen that make it really prudent, the prudent thing to do to have it updated, or maybe even completely a new plan put in place.
Me personally, with young kiddos, my husband and I always get nervous when we go out of town and leave the kiddos. So I always do a double check, because so much can change. Even if you love and trust the same people you had designated, their situation may have changed. They may have too much on their plate to be able to handle, your mess that you may leave them. So just and definitely when we travel is when I remember to look back. I often tell people, honestly, every 5 to 10 years, do a double check. These days, with so many accounts and passwords, I also think it's a good idea to kind of update a list, for your family to be able, and you, just to be able, to make sure that you kind of have an inventory of all your things, where things are located, who to contact, financial advisor. And, all of that information changes yearly. I know we're all busy, so it doesn't happen as often as it should, but typically every 5 to 10 years, definitely look at your situation and everyone else's to make sure you shouldn't change, who you previously designated for some of those roles.
That is such a good point about the life circumstances of the people you might have named when you're, maybe, for example, when your children were first born. Jump forward 10 years, they could have health problems. They could have moved, out of your community, or, live somewhere you wouldn't want your kids to have to move to. Yeah. You may have named your parents because when your kids were little, they were, healthy and vigorous enough to take on that if they had to at that point. But maybe 10, 15 years later, that's no longer the case. So that's really a good thought. So what is I'm going to talk a little bit about DIY estate planning. So when people try to get online and maybe do some quick documents, what is a DIY mistake you see when someone tries to do it on the cheap, and what does it cost the family later? And of course, it doesn't always happen that the DIY estate planning doesn't work, but we see it every day, instances where it doesn't.
One horror story from a DIY will was a lady, and her, from the get-go, the will was valid. It, checked all the boxes that it needed to. She named certain things to go to certain people, but she forgot to, we call it a residuary clause, meaning and everything else will go to X, Y, and Z. So she only listed certain property. Come to find out, she owned millions of dollars worth of minerals that she did not, she didn't have and everything else to these certain people. So it ended up, again, going back to what we previously talked about, where Texas had to figure out who her heirs were that would get, all the other property. And Sharon ended up going to a sibling that we knew she couldn't stand. And so that was a hard pill to swallow, because I knew that's not what she would have wanted. We knew the family. But that one always sits out. So a lot of times it's, failing to include just the right things that most people wouldn't think about if they weren't, in this world. Failing to include everything, failing to execute it properly. So like maybe typing it out and then signing. There's so many technical aspects to allow the will to be valid in Texas, and so many times it's not when people try to DIY.
So if someone is listening to this and they are feeling a little bit overwhelmed, or they know, okay, I'm behind on this, maybe I have kids and I don't have estate planning, or we did estate planning when the kids were little, but my goodness, that was 20 years ago and life circumstances have changed and they are feeling just a little overwhelmed. How do you suggest they approach? I mean, obviously, I'm going to recommend that they just call our office or go online to ZieglerEstatelaw.com and request a consultation. It's a free consultation. It's entirely free to them, and it will allow them to sit down with one of our attorneys, and we're going to spend quite a bit of time before their appointment gathering information from them. It's going to be a little annoying, I will warn you out there if you're listening. Only annoying in the sense that we really do need to kind of have a good picture of your situation so that we can plan, so that we can start coming up with strategies that might be appropriate for you in your estate planning, that fit your family, that fit your assets, for what you have and what you want to have happen to it, and who you trust in your life to help make decisions if you do have a care journey before you pass, and what your health situation is. So my first impulse is to say, give us a call, because it costs you nothing to have that conversation with us. But in preparing for that meeting, anyone who's out there listening and thinks, yeah, I really need to get this taken care of, what are some of the biggest pieces of advice you can give them about preparing for that consultation, since you sit on the other side of the table, so to speak, and you're in these meetings helping to craft a plan for people every day? How do they prepare?
I will say, like you said, it can feel overwhelming, but to, not feel that way. When we set up an appointment, we walk through some of those questions, and we will ask questions. A lot of times we say, we're not trying to be nosy, and go into a list of questions. And that's just to try to really get you thinking, because a lot of times you don't really think about everything. All of us, are at fault to doing that sometimes. To prepare for the meeting, or to prepare just in general, even if, they don't reach out to us, I would say, looking over, kind of getting an inventory going of your assets and where they're located. What does the account agreement say? How is property titled? And that's a good place to start. And then having the conversation, whether it's with your spouse or just with yourself, on some of the people you would want to possibly designate. Because a lot of times that's, it's not an easy answer. And so just to start thinking on the process is a good place to start. And it helps us when you've already started thinking on that.
Yes. It helps, I think, too, especially, I think people tend to think a little bit more about their property and where they would want, what they would want to have happen with their property. Although I know there are follow-up questions, certainly, that we ask, especially in a blended family situation, to help tease out those what answers. Ifs. Yeah. But on the powers of attorney, sometimes that's a tricky one in terms of, maybe you have one child who's great. I'm going to use my CPA example. You have one child who's a CPA that would be great to serve as your financial power of attorney, but maybe they don't live in the same town as you, and you trust your daughter who lives near you. She may not be a CPA, but you trust her. And so just thinking about, do I want to name two people, both my son and my daughter, to be agents on my financial power of attorney for practical reasons? And how am I going to have them act? Do they have the power to act independently for me, or do they have to agree and everything requires two signatures? I mean, all of that is stuff that I wouldn't think of if I were not involved in the firm.
Definitely. Yes. And it's kind of a trickle effect when we get into those meetings. They, every time somebody says, well, I haven't really thought about that. And it takes a minute. It definitely takes a minute to process, even when you have very trustworthy kiddos. Like you said, you have to think about everything, logistics, trustworthiness. And, it's hard for people. We all think we're going to live forever. And that's, I'll make my decisions if I'm alive. And we can be the kind of the realist, I guess, in the situation and tell you some, stories that what we have seen that, that's not necessarily the case. And you need to plan because you likely will need somebody at some point in your life. We may all need the help.
So true. So true. Well, Sharon, thank you so much for joining me today for this conversation. We hope that those of you out there listening, it's been helpful. And we appreciate everything that you do for the firm and our clients every day. You just do amazing work. And thank you for joining us today for a great conversation.
Thank you, Sondra. It was fun.
A quick reminder that today's conversation is for educational purposes only. It is not meant to be legal advice, because to give you legal advice, we need to meet with you and know your specific situation. Thanks again for joining us today for this conversation, and remember to make the second half the best half.